Well, good evening, and thank you very much for that lovely introduction. And thank you particularly for singling out the great Florence Isbell for attention tonight. I had the pleasure of sitting next to Florence. I've known her for more years than either one of us wants to admit, and she's a wonderful person, and I'm thrilled that she came tonight. I like the idea of being an alumnus of the court. I mean, I have to tell people I'm no longer a judge, and they say, yeah, but we still call you a judge. I said, fine, keep calling me judge. But I'm not anymore. Well, I was surprised to receive Art Spitzer's invitation to speak tonight. Art and I go back a long way, too, and we've been on the opposite sides of some issues, and sometimes I rule for him, sometimes against him, and he knows me to be something of a contrarian, and I admire his willingness to take the risk of inviting me one more time. But then I put two and two together, and I figured that he probably expected me to talk about my FISA Court experience or NSA surveillance or both. But it has been more than 8 years since I resigned from the FISA Court after President Bush and General Hayden turned the Foreign Intelligence Surveillance Act into a Potemkin village. I have spent most of that time not talking about the FISA. At first because I thought it was illegal to disclose classified information. Silly me. Just think I could be living a good life in Russia now. And then more recently because 8-year-old knowledge of something as fast-moving as surveillance technology is stale and of little public interest. So it was both a surprise and, for me, a considerable honor to be asked to speak to the ACLU about privacy, a subject on which many in this room are far more expert than I. For those among you who are privacy wonks, what I have to say may be obvious or old hat or simplistic, and for that I apologize, but it is a message that I think needs to be heard in Main Street America. The message is this: don't rely on the Constitution to protect your privacy. It won't. Not anytime soon. The idea of privacy is more cultural than legal anyway, and to preserve it, we need education more than we need litigation. Sorry about that, Art. You'll have lots of litigation to do anyway. The so-called right of privacy is not in the Constitution, of course. Its provenance is usually traced to a Harvard Law Review article of 1890 written by Louis Brandeis, co-authored by Louis Brandeis, that argued for a right to be let alone. But it wasn't until 40 years later, when Brandeis had reached the Supreme Court, that that idea surfaced in a constitutional case, and then only in a Brandeis dissent. The question was whether wiretapping was a search under the Fourth Amendment, and the court said no, the government wasn't intruding upon the defendant's person or his home or his effects or his papers. It was only listening to the words he spoke out loud. And it took another 40 years for the court to come around to the view that someone who enters a phone booth, as long as he closes the door, is entitled to assume that the words he utters into the mouthpiece will not be broadcast to the world. That, as most of you know, was the Katz case. And it was the Katz case that gave us Justice Harlan's famous reasonable expectation of privacy test. But the court's opinion did not recognize a general right of privacy then, and has not done so to this day. The right to be let alone, the court said, is left largely to the law of the individual states. And yesterday we got an idea what that means. After Katz came the problem of defining a reasonable expectation of privacy. In 1979, we're getting into our territory now, The court found no reasonable expectation of privacy in the telephone records, that is, the numbers we dial and the numbers that dial us, because when we make a phone call, we are voluntarily, this is the Supreme Court's language, we are voluntarily conveying numerical information to the telephone company. It is too much to believe, the court said, too much to believe that telephone subscribers harbor any general expectation that the numbers they dial will remain secret. That case, as most of you know, was called Smith versus Maryland. Sonia Sotomayor was 25 years old when that case was decided, and presumably a telephone subscriber. She certainly did not harbor the expectation that dialed telephone numbers were secret. She was a prosecutor. But 30-plus years later, her intriguing concurring opinion in the GPS tracking case called Jones asked whether the expectation of privacy calculus has changed. It may be unreasonable for me to assume that I can cruise around town in my Jeep without being observed and followed. But do I not have a reasonable expectation of privacy in the whole story of my movement for a whole month? Every inch of my Jeep's movement, where it went, what route it followed, how long it stayed? Now that we have GPS devices, cell location technology, closed-circuit television, video, automatic toll collection systems, and more, Justice Sotomayor points out, our movements can be recorded, this is her language, recorded and aggregated in a manner that enables the government, more or less at will, to ascertain our political and religious beliefs, sexual habits, and so on. Does such intense, extended surveillance violate the protection afforded by the reasonable expectation of privacy test? Well, I don't know, and neither did the Supreme Court. And Justice Scalia, writing for the court, was not about to let a drug conspiracy conviction stand or fall on something as indeterminate as the defendant's subjective expectation of privacy or a jury's decision whether or not that expectation was reasonable. Instead, he fell back to the pre-Katz trespassory idea of what is a search, the warrantless physical attachment of the GPS device to the undercarriage of the Jeep violated the Fourth Amendment guarantee that the defendant would be secure in his effects. His Jeep was his effects. Justice Scalia even managed to fit this analysis into his Procrustean bed of originalism. We have no doubt, he wrote, that such a physical intrusion would have been considered a search within the meaning of the Fourth Amendment when it was adopted. He is right. People back then kept their GPS devices with their AK-47s. Justice Sotomayor's concurrence suggests that it may be time to reconsider the premise that an individual has no reasonable expectation of privacy in information voluntarily disclosed to third parties. But Justice Alito's analysis demonstrates why that's not going to happen anytime soon. Relatively short-term monitoring of a person's movements on public streets, he suggests, wouldn't violate anybody's privacy. But longer-term GPS monitoring does. What? How short is short? How long is long? This is a quote from Justice Alito. We need not identify with precision the point at which the tracking of this vehicle became a search, but the line was surely crossed before the 4-week mark. I feel pretty comfortable on the limb I'm walking out on here. The warrantless collection of telephone records has been legal since Smith versus Maryland in 1975. The bulk collection of metadata is Smith versus Maryland, squared, or maybe to the 10th power. But there is no metric for deciding when the difference between a pen register and bulk metadata collection becomes a difference in kind and not degree, or for assessing the public's idea of whether my expectation of privacy is reasonable or not. It will be years, I think, before the Supreme Court accepts Justice Sotomayor's suggestion to rethink the jurisprudence of privacy. NSA metadata collection may indeed be unauthorized by Section 215 of the Patriot Act. As the Privacy and Civil Liberty Oversight Board's excellent report, recent report argues, and as I gather Joe Onek is arguing to the FISA Court now. And it seems likely to be laid low, this program laid low or maybe driven back underground by politics anyway. But I have to tell you, ACLU, I don't think it's unconstitutional. Now, the more troubling question Justice Sotomayor asks is whether advances in surveillance techniques will shape the evolution of societal privacy expectations. Whether, in other words, as surveillance technology gets more and more effective, our expectations of privacy get lower and lower. Critics call this problem the circularity of the expectation of privacy test, because if surveillance gets better and our expectations are reduced, then the protection afforded by the Fourth Amendment is reduced as well. That question ought to make us worry. Not so much about what the government has done or might do or could do to us, as what we are doing to ourselves. A few of you will remember that 45 years ago, about when Justice Harlan announced his reasonable expectation test, there was something of an epidemic of airplane hijacking. The response of the airlines and the government was the empty your pockets, take off your belt, put your bag on the conveyor drill that is now hardwired as part of the flying experience. I was a young civil rights lawyer then, well, pretty young. And I remember thinking, this is terrible. This is an invasion of my privacy. If this continues, Americans are going to lose their instinct for privacy. I have given myself full marks for prescience. It has happened. We all have internet connections. We accept cookies on our devices. Almost all of us have Facebook or LinkedIn accounts. All our grandchildren do. Every credit card transaction, every SKU that is part of every credit card transaction becomes part of what we now call big data. We know that Google reads our mail because it sends us ads for what we were just searching for on the internet. Have you heard the story? This is not an urban myth. Have you heard the story of the man who stormed into a Target store to chew them out for sending coupons for baby clothes and cribs to his teenage daughter? He returned a few weeks ago to apologize. His daughter was pregnant. She hadn't told her parents, but Target knew. Its computers not only discerned her pregnancy by finding patterns in her purchases, but because she was buying unscented lotions, it figured out that she was at the beginning of her second trimester. Big data and its co-conspirator, the Internet of Things, are to our privacy as Vladimir Putin is to Ukraine. I would like to talk about it for hours, but art has the hook here. So I have a few reading suggestions for you. Catherine Crump, a staff attorney in the ACLU Speech, Privacy, and Technology Project, and Matthew Harwood, a media strategist at the ACLU, posted a blog on March 25th headed invasion of the data snatchers. Big data and the Internet of Things means the surveillance of everything. Read it and tell me if anyone has any reasonable expectation of privacy anywhere anymore. Dave Eggers published a novel last year called The Circle. It has been called dystopian. Literary critics complain that it explains too much. Read it. If you believe that transparency is the way to go, read it. And tell me if you still think so. And of course, Jeffrey Rosen's The Unwanted Gaze, The Destruction of Privacy in America. This book, first published 14 years ago, before metadata collection, before big data, before the Internet of Things, is a work of prophecy. Let me read just a few words from Rosen's epilogue. He writes, "We are beginning to learn how much may be lost in a culture of transparency. The capacity for creativity and eccentricity, for the development of self and soul, for understanding, friendship, and even love. Privacy is a form of opacity, and opacity has its values. We need more shades and more blinds and more virtual curtains. Someday, perhaps, we will look back with nostalgia on a society that still believed opacity was possible and was shocked to discover what happens when it is not." I end where I started, with the observation that privacy is a cultural matter that will not be much affected by litigation. If that sounds like a marketing message from one who retired from litigating to become a judge, and then retired from judging to become a mediator and an arbitrator, well, you may think that, but I couldn't possibly comment. Thank you very much.